So welcome, everybody. It's great to have you here. We have a small group in person. I think the holidays have kept people at home on their computers, but welcome everyone who came and welcome everyone on the internet. This is World Arbitration Update. This is the last of, I believe the count is 23 panels over the last 6 days. Um, we started in Mexico City last Thursday at the National Autonomous University in Mexico City, had 8 great sessions there on investor state arbitration and arbitration in Latin America. And on Monday, we moved to panels addressing issues in Africa and the Middle East. Then Tuesday, Oceania and Asia, Europe yesterday, and then today, finishing off with all the best panels. So I should, for those of you who are new to World Arbitration Update, my name is Ian Laird. I am co-chair of the conference. We founded World Arbitration Update 3 years ago. And it was created kind of in reaction to a great degree to the COVID pandemic. We weren't doing our usual, dozen conferences a year as happens in the international arbitration community. People were stuck in their offices and at home. And we thought it would be a great way to truly reflect the international dimension of international arbitration that truly reflected the diversity and the global nature of international arbitration all over the world, that we have practitioners and arbitrators from every corner of the world. And now that we're kind of getting back together, we're slowly all going to conferences and arbitration weeks, seemingly in every city. But we decided that there was still room in the agenda for a virtual conference like this. We have had a few in-person elements, and I think we're going to continue to do that. But this really has given us a chance to connect with a wide group of people from all over the world, and it's been a fantastic week. And I just wanted to take the opportunity to say a few thanks, because you can't do this kind of conference without a lot of help. And we've had a great advisory committee who's worked closely with us in developing the topics. Of course, the folks at the National Autonomous University in Mexico City put a great deal of effort in organizing their part of the conference. I have to say and mention our key organizers like Strategy LLP here in Washington, D.C. in Bogota. And that's Dr. Jose Antonio Rivas's firm. He is, the co-chair of WOW, of World Arbitration Update. I would say, he's really the driving force, along with Maria Lucia Casa, who I think you've all seen her emails. She is an incredible organizer and lawyer, and absolutely this couldn't run without her. And as well, Juan Pablo Rodriguez has played an outsized role in making sure all the trains literally run on time. So thank you to them, and thank you to all of our sponsors. We've had an incredible support from the legal community. You can just see that by the fantastic speakers and moderators that we've had in the various panels over the past 6 days. So thank you to everyone. So here we are addressing what I think is perhaps one of the most interesting topics, and I think my fellow panelists will likely agree, which, really doesn't say much about what, kind of interests us. Other people like sports, other people like, music. We're, into working group 3 of UNCITRAL. That's kind of our thing, and ICSID reform, all of which has taken up a lot of time and thinking and efforts by a great many people over the last few years. And we're going to make that the topic of our discussion today in a panel that's titled "The Code of Conduct for Adjudicators in International Investments Disputes is a Reality?" exclamation mark. Now, I didn't write that title. I think Jose Antonio did, but clearly the exclamation mark is to indicate the enthusiasm that I've tried to give that effect, because there's been a great deal of effort and a lot of time and work to get to the point where there have been some meaningful reforms. And I think a great deal of credit goes to a lot of people at UNCITRAL Working Group 3, as well as at ICSID for driving those efforts. And luckily, we have a panel today which will really provide you with some insights into that process, where we've come and where we'll be going in the future. And let me just introduce our panelists, and then we'll get going on the discussion. Our presenter, and she'll present in a moment, is Professor Chiara Giorgetti, who teaches international law and international arbitration at Richmond Law School and is a senior fellow at Columbia Law School's International Claims and Reparation Project. Her publications include several articles and blog posts on the draft code and the book Recusal of Arbitrators and Judges in International Courts and Tribunals. And I certainly recommend everyone have a look at that. Her practice focuses on international disputes and international investment arbitration, and she is a participant, active one, in Working Group 3 negotiations on behalf of the ITA. In 2019-20, she was a scholar and resident at ICSID working on the first draft of the code, and we're really privileged to have Professor Giorgetti here today. Further down the table, 3 over from me, we have Maren Carlson. She's the co-leader of Sidley Austin's Global Arbitration, Trade, and Advocacy practice. She focuses her practice in international investor-state disputes and has for 25 years represented both cross-border investors as well as respondent governments in ICSID and UNCITRAL arbitrations under various BITs and trade agreements. Her cases have spanned many sectors: financial services to energy to manufacturing to infrastructure development. And she is, like many of us, circled the globe from Latin America to Europe to Asia. As well, she teaches here at George Washington University, and we've got a few folks here in person, and American University's Law School, and has held leadership roles at the ASIL and the Foundation for International Arbitration Advocacy. So that's great to have Martina here, a real privilege as well. Sorry, Maren. Now I'm looking actually to next to Maren is Martina Polasek, and who is a Deputy Secretary General of ICSID. And Martina has been directly involved in the work on the Code of Conduct and contributed to the Working Group 3 discussions on behalf of ICSID. So another very knowledgeable person who's been involved in these discussions for the last few years. She started at ICSID way back in September 2001. So a real veteran of the growth of ICSID and seeing all the developments over the last years. Prior to that, she was an attorney in Paris at Adjudicators et Associés, and before that in White and Case. And she holds degrees from GW Law. Oh, way to go, GW. We got a GW thing going today, as well as University of Paris 5 René Descartes and the University of Gothenburg. Welcome. It's great to have Martina here. And down at the end of the table is Lauren Mendel, who's an international trade and investment attorney. He's worked for many years in negotiating free trade agreements and bilateral investment treaty agreements, and working on the disputes related to those types of agreements. His recent tenure was at the Office of the U.S. Trade Representative, USTR, and he served as the U.S.'s lead negotiator of the investment chapter of the U.S.-Mexico agreement, USMCA, and played a major role in other signature negotiations under the Obama and Trump administrations. Mr. Mandel is also a litigator and has successfully resolved disputes at the WTO under those dispute settlement mechanisms, ISDS, commercial arbitration, and US courts. And he's particularly focused as well on navigating trade and investment agreements involving China. Appropriately, as per the rest of this group, he's been an observer at the UNCITRAL Working Group 3 on behalf of the US CIB. And then finally, and not least, we have the privilege here today of having Jae-Sung Lee here. He's the Senior Legal Officer at the International Trade Law Division of the United Nations Office of Legal Affairs, the UNCITRAL's Secretariat. And he is currently functions as the Secretary of Working Group 3 on Investor State Dispute Settlement Reform, and has served as Secretary of Working Groups on Dispute Settlement, Electronic Commerce, and Secure Transactions. Before joining the UN in 2007, Jae-Sung served in the Korean Ministry of Foreign Affairs. He's a Korean national and is a graduate of Seoul National University College of Law and holds LLMs from Seoul National University and NYU Law School, as well as having a PhD from Seoul National University. So as you can see, we have an all-star group of folks here who are very well connected with the recent reforms at UNCITRAL and ICSID. And it's a real pleasure to have you all here, and thank you for taking time to come today. We are going to start our discussion with a brief initial presentation by Professor Giorgetti, setting out some of the basically setting the table for our further discussion on some of these most recent developments at Working Group 3. In particular, we're going to focus on the Code of Conduct. And I will now pass the microphone over to Kiera.
Thank you very much, Ian, for the kind introduction and for inviting me today. And thank you, of course, to the Washington Arbitration Update. It's really a pleasure to be here today with all of you, with my esteemed co-panelists, and really looking forward to the discussion. When I was invited to the discussion, I thought, well, this is interesting to think about kind of a post-mortem of the negotiation of the code. But I also realized that together with the post-mortem of the negotiation, we really look at also the ante vitam, right? So before the code actually gets into implementation. So I think it's a wonderful opportunity for us to be together and discuss. So the code was finally approved or agreed. The text of the code was finally agreed upon very recently at the 45th session of the UNCITRAL Working Group 3 that took place in New York, and many of us were there. I was there, unfortunately, only online, but it was a great event, and it took us until the very end. We weren't sure whether an agreement was going to be reached. But most of us also know that this has been a long path that began in 2017 when Working Group 3 essentially in October 2019, the Working Group 3 requested together, the UNCITRAL Secretariat together with the Secretariat of ICSID to prepare a draft code after they had already talked about what the draft code should contain. And the Secretariat then released the first draft code of the code for discussion in May 2020. And there have been several discussions and several drafts of the code throughout this period, even with the COVID-19 restrictions. So many of the discussions actually took place online. And finally, we reached an agreement very recently. And so now the code will be presented for final approval at the UNCITRAL Commission in July 2023. So what I would like to do today is giving a brief overview of the content of the code itself, and then maybe give some of my thoughts about the code. So the question is, so what's in the code? The code contains 12 articles and applies to arbitrators in and candidates for international investment dispute, also in the code called IID, which are defined in Article 1 as those disputes between an investor and a state or a regional economic integration organization pursuant to, and there have been quite a substantial discussion in the negotiation on this, but pursuant to an investment or investor protection treaty, a contract, a domestic legislation, or a foreign investment, or a contract with a foreign investor. The code complements other applicable ethical provisions and does not override them. And consistent with its initial drafting, the code relies heavily on disclosure. And disclosure is the center of Article 11. And Article 11 provides a general disclosure obligation first that requires candidates and arbitrators to, and I quote, disclose any circumstances likely to give rise to justifiable doubts of their independence or impartiality. And then there's a second part of the code, of the Article 11, that specifies some of the items that need to be disclosed, including all IIDs and related proceedings and any appointments as arbitrator, legal representative, or expert witness by a disputing party in the past 5 years. Any prospective concurrent appointment as legal representative or expert witness in any other IID or related proceedings must also be disclosed. Discussion on disclosures of any third-party finding also continued until the very end of the negotiation. And it was ultimately agreed that arbitrators and candidates should disclose, and I quote here again, any financial or personal interest in the outcome of the IID proceeding, any other proceeding involving the same measures, and any other proceedings involving a disputing party or a person or an entity identified by a disputing party or being related. Another key provision of the code is Article 3, and that defines the key concept of independence and impartiality. The general obligation of being independent and impartiality is regulated in the first paragraph, while the following second paragraph provides a non-exhaustive list of essentially negative obligations. And so here you have the same drafted technique, first a general provision and a general paragraph, and then more specific issues. And so this second paragraph, for example, includes the prohibition so that arbitrators should not be influenced by loyalty to any disputing party or other person or entity, be influenced by any past, present, or prospective financial, business, professional, or personal relationship, or assume any function or accept any as well. And as well also not to use his or her position to advance any financial or personal interest he or she may have in the disputing party or in the outcome of the IID proceeding. And then there are others. I think it's quite interesting to read specifically the provision included in Article 3. One of the interesting part also of the code is how to regulate multiple heading and double heading. And in fact, how to regulate the issue of multiple roles as arbitrators, counsel, and expert, which is typical of ISDS, played by some actor, was one of the most debated bones of contention up to the very, very end of the negotiation. And in fact, it was resolved only essentially at the end of the day of negotiation. It almost derailed the negotiation themselves. And here there were several kind of interests. On one side, some negotiators highlighted concerns about the integrity of the process and the ISDS system, the issue of independence and impartiality, and the need to avoid appearance of bias. On the other, some stakeholders were concerned that that parties would have their choice of arbitrators restricted, and also highlighted the possible problem of the reduction of the pool of arbitrators and the repercussion on diversity. Eventually, the compromise that was reached, as I said, in the 11th hour, was to enhance disclosure, therefore Article 11, the inclusion of an obligation not to be influenced by prospective relationship, then in Article 3, and then a more specific regulation of multiple roles, specifically in Article 4. Article 4 has been the most controversial and one that has been discussed really in depth by all the negotiators. And here there have been several views. There are views on how to limit roles, diverged. And on one side, some wanted a total ban of double heading. Others said, well, disclosure would be sufficient. At the end, after prolonged debate, it was agreed that regulating how double heading would work was preferable. But obviously, then the issue was, how do you want to regulate? How does it work? So eventually, a draft was proposed. And in the last session, there was a final version that was agreed upon. Paragraph 1 prohibits concurrent double heading as arbitrator, counsel, or expert in proceeding involving the same measures, the same or related parties, or the same provision of the same instrument of consent. And then discussion then focused on very much on the duration of the necessary cooling off period that was necessary for former arbitrator to take counsel or expert appointments after arbitral proceedings were concluded. At the end, paragraphs 2 and 4, 224 of Article 4 provided that a cooling off period varied from 3 years to 1 year. So provided that for 3 years for any other IID or related proceedings involving the same measure or involving the same or related parties, so kind of the same language, and 1 year only for proceeding related to the same provision of the same instrument of consent. The disputing parties, and this is very important, so the disputing parties were the person in relation to the person that served as arbitrator, can in all circumstances agree otherwise and essentially waive this prohibition. So these were the main provisions, I would think, Articles 3, 11, and 4, but of course the code covers many other issues too. It regulates ex parte communication, confidentiality obligation, the duty of diligence, issue related to integrity and competence, fees and expenses, and the role of assistant. I'm not saying that these are not important, because these are very important, but they were just less controversial when they were negotiated. So what do we think about the code? Is this a success, or have we missed an opportunity to do maybe a little more? I think overall the code is a good compromise and is a much welcomed development in the process of reform of ISDS. First, and I think it's very important, it clarifies the applicable ethical standards. This is really fundamentally quite consequential. There've been a lot of discussions about ethics and what were the different standards. And now all the players in ISDS understand what the ethical expectations are and what the requirements are. So the fact that we have this, I think, is very relevant. Second, the code is an important element of the ISDS reform process in general, and enhance also the legitimacy of the process in ISDS itself. Third, the code includes well-reasoned and balanced provision, very much discussed, and that build on existing practice on ethical issues, and also respond to calls for reform. The fact that it is rooted on disclosures also follows and builds on international precedents that already exist. And finally, the commentary that will accompany the code, that will come with the code, will also be important and will clarify its application. So this is for all the advantages. However, there have been, I think, some very important missed opportunities. First one, it's not very clear at all how the code will be implemented and enforced, and this is very important. The code will be made available for the use by disputing parties, institutions, and states, but negotiators postponed the discussion on how to make it binding, and possibly this is possible by inclusion in multilateral instruments, on ISD forums, or at a later stage, but we don't know yet what will happen. And also it is not clear how the provision of the code will be enforced, and there is no overarching institution tasked now with monitoring and enforcing compliance. Article 12 on compliance, I think, is quite weak in general and provides only that an arbitrator and a candidate shall comply with the provision of the code, and that they should not accept appointments or will resign if they're not able to comply with the provision. Challenges and disqualification will continue to be governed by the applicable rules or by instrument of consent. Additionally, we don't have only one code. Now we have two codes. There's one code that applies to arbitrators and another code that applies to judges. At the beginning of the process, the code was supposed to be one and cover all kind of adjudicators. Now we have two. I don't think this is welcome because it will likely lead to a possible disjuncture of the application of the code and of understanding of the ethics implications also. And of course, we don't know whether the code for judges, how the code for judges will be implemented. We don't have judges yet. And finally, although it is true that the code was discussed and approved swiftly for international, in terms of international legal negotiation generally, it still took longer than previously expected by the negotiator at UNCITRAL and Working Group 3. And I'm not sure what this means for the future negotiations of other ISDS reforms that are forthcoming. But anyways, I'm really looking forward. I just wanted to give a general overview of the code and give you a little bit of my take, but I very much look forward to hearing what others have to say. Thank you.
Well, thanks very much, Chiara. That was really helpful in kind of setting the stage for our discussion. I think you raised a really important point concerning the question of implementation. I think the code obviously has taken some great leaps ahead in addressing some issues that needed to be addressed. But as you say, there remains hanging over the new code how this will actually work. Certainly these are, I think, from a soft law point of view, great standards which we'll all want to look to adhere to, and I think arbitrators and counsel will be enthusiastic. But at the end of the day, soft law can only go so far. So maybe the first question should go to ICSID, because we have an institution here which was very directly involved in the work on the code. And it'd be great to hear from you, Martina, as to your thoughts on that issue.
Thank you, Ian, and pleasure to be here. Thank you so much for inviting me on behalf of ICSID. It's obviously a very relevant topic as the code is coming up for approval by the Commission in July. So on implementation, now the chair of the working group has advised delegates that the code will be applied as soft law for the next 5 years or so, probably. It may be reconsidered if and when the working group gets to a multilateral instrument on ISDS reforms, the MIRA. Closer? So the code will become a soft law instrument, at least in the short term. Now, what does this mean? Well, it means that, yeah, still up, even closer. It means that it will be available for application the same way under any rules, under the ICSID rules, under UNCITRAL or SEC, basically under any rules. The parties could agree to apply the code, preferably early in the proceeding before the appointment of arbitrators. But that could be at any time, really. It depends on the parties and if they wish to apply the code. Or they could refer to it as a guidance instruments. So this is sometimes done with regard to other soft law instruments. For instance, the IBA rules on the taking of evidence. It's often referred to in a procedural order to guide the tribunal, not to apply it formally, but to guide it. Now, in any event, it is likely that the code will be used and relied on when parties are making arguments about the independence and impartiality of arbitrators. So that's what we expect will happen. And ICSID would apply the code if the parties agree to apply the code. Now, it's also been the case with the IBA guidelines that they have been referred to as soft law instruments in accordance, especially in connection with challenges to arbitrators. Now, the advantage of keeping the code as soft law is really that it allows the same application across the different sets of rules. And it also works well in the ICSID context. And in fact, ICSID already took proactive steps in its rule amendment process to deal with arbitrator conduct. Many of the rules that we adopted are reflected in the code, and they really set high standards for ICSID arbitrators. Now, most importantly, we adopted a new arbitrator declaration that's attached to the rules. It's in the back of our new booklets, the 2022 ICSID rules. And it contains some of these really important components. Obviously, a declaration that the arbitrator will be independent and impartial. So that reflects the obligation in Article 3 of the code. It has a broad disclosure requirement, for instance, to disclose all significant relationships, including third-party funders, with the parties and others. And the need to disclose all investor state cases that the arbitrator has been involved in any capacity. And then a broad catch-all phrase that, other circumstances that may reasonably cause independence and impartiality to be questioned. So while the disclosure requirement is not as detailed as Article 11 of the code, it is equally broad. Now, there's a third point that's worth mentioning. It's the confirmation about availability in the declaration, the ICSID declaration. And the requirement that you have to show that you are available for the next 2 years. And this is complemented by provisions in the arbitration rules that, push the arbitrators to meet deadlines and act expeditiously. So that corresponds to the duty of diligence, Article 5 of the code. There's a confidentiality undertaking, an undertaking not to have ex parte communications, and to adhere to the memo on the fees of and expenses in ICSID. And those are also reflected as obligations in the code. So really, the code reaffirms undertakings under the ICSID rules and really complements them where they are more detailed in the code. Now, enforcement, and as you note, that this is an issue that's left to the applicable rules. So for ICSID, this means that the challenge provisions in the ICSID convention and arbitration rules apply. And the standard for a successful challenge also depends on the applicable rules. So for ICSID, that means that an arbitrator can be challenged if he or she is not independent and impartial and doesn't have the required qualities like high moral character and recognized competence. And as you know, the standard at ICSID is manifest lack of those qualities. But at the same time, case law has interpreted that as the justifiable doubts based on the knowledge of a reasonable third party, knowing the facts and circumstances. So it's really, the ICSID standard is aligned with the UNCITRAL rules and the additional facility rules. So in order to succeed on a challenge, a party challenging an arbitrator because of a breach of the code would need to show that the relevant conduct falls within the grounds for a challenge under the convention, and that the standard for a successful challenge is met. I'll stop there.
Well, thanks very much, Martina. That was a really good initial take on those issues. Implementation clearly is going to be key, and sounds like there's a plan in place. Maybe we'll get to hard law at some point, but as you say, the IBA rules on conflict and the IBA rules on evidence have been used for many years and had a lot of impact on tribunals. And this is just going to be one of those issues which arbitrators and parties will now have to consider and make their decisions on how they want to run their arbitrations. And it's just another tool in the toolbox. But Marin, Martina's brought up a lot of good points. Clearly, enforcement has always bedeviled the international arbitration community because of the diverse nature of these tribunals. ICSID has been working hard on these issues, and the reforms reflected that. But what are your thoughts on kind of the implementation direction and on enforcement?
Right. I mean, I think I would echo what you just said, Ian, which is that it has been sort of voiced as a criticism of the code that it isn't binding, that we haven't turned it into an immediately binding hard law treaty. And I'd actually posit that may or may not be necessary, right? Because does it need to be binding? I mean, the example you just gave, the IBA guidelines, whether it's the IBA guidelines on the taking of evidence or the IBA guidelines on conflicts. Now, obviously, the thought was that the IBA guidelines on conflicts weren't sufficient. We needed more. We wanted more specificity and more detail in the ISDS space. But I don't think that the thought was that reform was needed because the IBA guidelines weren't binding. It was because we wanted more. We wanted more detail. We wanted more control, more controls, more regulation, if you will. And in its soft law form, I think we can safely say that as soon as the code is adopted in July, or well, frankly, I'm sure actually it's probably already happening in challenges right now, you're going to see this code cited in every challenge. I think every arbitrator who's being appointed, I mean, the ICSID disclosures are clear about what they have to disclose, but I think even in an uncitral or an ad hoc case, anyone who's appointed is going to follow the disclosure provisions, whether they're required to do so by an institution or not. Simply because we are all sort of risk-averse creatures, if nothing else. Unless you're taking like some sort of personal Alamo stand against disclosure, you're going to disclose what's requested in these guidelines. I think counsel, whether or not binding, is not going to appoint an arbitrator, or is certainly going to think very hard about appointing an arbitrator who has a concurrent role within the 1 or the 3 year windows. And parties and institutions, of course, when they're setting up their PO1s, the procedural order number 1, can bring in those same cross references that we all will already see as a fairly standard matter of course to the IBA guidelines. So in a way, I'm not sure that we need to go as far as additional steps to make it binding, because I think they're going to have an immediate impact. But okay, if you wanted to make it binding, let's say that we collectively decide that that's an important thing to do. How might we do that? Of course, you can amend the institutional rules to refer to the code. I will defer to Martina as to whether she feels like going through another ICSID rules amendment. I bet I know the answer, at least anytime soon. Obviously, treaty negotiators can incorporate references to the code into forthcoming treaty texts. You could think about a multilateral convention. It occurs to me that also you could just do a multilateral declaration, right? Where you have something where all of the states who want to sign on to it declare that they will apply the code that the code will be applicable in all disputes governed by an instrument between somebody else who's also signed on to the declaration. In essence, make it a multilateral interpretation, or a subsequent agreement on the interpretation of every bilateral investment treaty that's signed on to by 2 declarants under the VCLT. So there are means by which we can make this binding if we think it's necessary to do so. But I'm not entirely sure that we need to, because I think it's going to become part of our fabric of investor state arbitration and the backdrop against which challenges and set aside proceedings are going to use it as a reference, whether we make it binding or not.
I wanted to kind of dive into an issue. We're going to get to double hatting, and I'm not going to go there yet, but there is an enforcement element of double hatting. And as Kiara set out earlier, there is the element that when you become and this is a term of art, former arbitrator, that there are certain limitations, 3 years in some cases, 1 year in others. Apart from how you define a former arbitrator, which I think is actually a rather fraught term, because as we know, revisions, interpretations can occur after awards. There's, depending on if it's an uncitral arbitration and you're in you have a foreign lex arbitri, which may include the possibility of referring back to the tribunal. The question is, when do you become a former arbitrator? We can't answer that. I imagine the parties, whenever this is debated, will have views on that, but that in itself is problematic. But who's going to enforce that? I mean, say someone is at 2 years, 11 months, 9 days. Who's going to bring that up, and how do you enforce against a former arbitrator? There's no tribunal. There's no institution that's tasked with enforcing these provisions. And, they're paid out, they're gone. Arguably, the tribunal is functus officio. What's the view on that? Or is there no view? Maybe I could ask Martina to weigh in on that. And Marin, if you want to jump back in on that too.
Yeah. Well, thank you for that. yes, I realize that the provisions on the limit on multiple roles may be hard to enforce for the various questions that you raise. We think that it makes sense to, as Maureen noted, to start applying this as soft law, and that there actually will be some form of self-regulation among arbitrators. I would be surprised if you, as counsel, someone in a counsel role and also acting as an arbitrator, would not sit down, look at the code, say, consider what it means and what it means for your practice, because I think that many people will think twice before taking on the role as an arbitrator when you are in a law firm that deals with cases under these instruments, in particular under a multilateral investment treaty. So there you may see fewer people acting in multiple roles in that scenario, the multilateral investment treaties in particular. But in terms of hard law, how you would implement that, I mean, yes, it would be easy to attach it to the ICSID rules. You don't necessarily need an ICSID rule amendment for that. But I think it's important that we at this time focus on implementing parity and uniformity across the board. And how do you achieve that? Well, you could attach to all sets of rules and do that at the same time so that we achieve uniformity, including UNCITRAL rules, including SEC, ICC, other forms of rules for investor state arbitration. That may make sense. You could also implement, as is being discussed, through AMIRA. But there, the question is, would you get full coverage? Depends on how many states join. So you may risk in actually getting more spotty coverage and more fragmentation. So you really need to consider the way forward in terms of how hard law implementation might work.
And I'll just throw in that I don't think you should underestimate the power of reputational effects. That former arbitrator, however defined, who's at 2 years, 11 months, and 9 days, does not want to be the subject of the first GAR article about how they've flouted the code and taken a counsel position. So it's not for nothing, those reputational effects.
Now, I'm going to move on to another topic, but I want to give Jay a chance to weigh in, because I know this is an issue or these issues concerning implementation and enforcement were certainly ones that were well ventilated. What's your thought? I mean, we've heard from the institution, we've heard from our practitioner, but coming from the UNCITRAL point of view, I mean, you can have a much wider view. I mean, this could be a convention, right? I mean, this could have been something much more hard lawish, but there clearly was a decision to kind of go this route, which I agree, is certainly valid and can have maximum effect. But what's your sense on this, Jay?
I think Martina already touched up on the fact that the likeliness of having a binding instrument is quite difficult to achieve. And I think what the working group decided to do was to actually go for uniform application of the ethical standards across the board, rather than trying to come up with a binding instrument which may be limited. Of course, one of the ideas was to actually attach it to the UNCITRAL arbitration rules, but that would only be limited to the UNCITRAL arbitration rules, similar to the rules on transparency, which was done only in the attachment to the UNCITRAL arbitration rules. So I think the working group was more comfortable preparing a soft law instrument for the time being. I think it was going to revert to self-regulations and reputations and practice to develop. And of course, this code is only one part of the first set of the reform elements that the working group is developing. Once the other reform elements are all completed, that will become part of the package, and it will become possibly the part of the multilateral instrument that Martina was referring to. So in that case, I think we can talk about more binding effect of the code once it becomes part of the multilateral instrument.
Right, and we'll hopefully have a bit of time at the end to talk a bit about kind of looking forward on the multilateral instrument front. So let me move on to another issue, which Kiara very helpfully set up for us earlier, and this is the idea that we have two codes. We have one for arbitrators and one for judges, and we used in the title of this session adjudicators because we wanted to kind of cover the whole ground, but clearly the working group made a decision to have this division, and partly I think it reflects and is looking forward to this idea of there being a multilateral investment court, and that there may be judges, a different kind of, not entirely arbitrators, judges working perhaps in the appellate mechanism or such. Lauren, if you could kind of at least touch on this issue, because I know it's an important one, and I thought it would warrant a little bit of commentary. So if you could just tell us your views on that.
Thank you, Ian, and thank you to the organizers, and apologies for the view of my chin. It's not the organizers' fault, it's my own technical limitations. With respect to the issue of two codes, I think some background is first warranted. I think as Kiara indicated, the code has gone through 5 drafts at the working group level. The first 3 versions of the code applied to arbitrators and, quote, judges on a permanent standing mechanism without distinction, though there were drafters' notes in those early drafts that raised questions of, is this provision appropriate for judges or not? It was not until the 4th version of the code in July of 2022, the first version to specify that some provisions in the code should only apply to arbitrators, some to judges, and various variations. And then in September of 2022, you see the big break in the working group meeting in Vienna when there was the decision taken to split the document into 2 codes. And that division is reflected in the 5th version from November of 2022, and in the current version that will go to the commission, the UNSTRAL commission, in July. Now, with that background in mind, I'll highlight that, in my role as an observer in the working group, I've sort of identified sort of three different strains of discussions around this issue of 2 codes that hopefully is useful to relay. The first question addressed by the working group, should you have different rules for arbitrators, ethics rules for arbitrators as compared to, quote, judges? Second, should you have 1 code or 2? Now, this is really an issue of form rather than substance. You could have 1 code that has different provisions applying to arbitrators versus judges, but this form question is nonetheless significant. And then third, if you're going to have separate rules or a separate code for judges, is now the time to negotiate those rules when, as has been discussed, the working group has not designed the court yet. I keep referring to judges in quotes because that is a term that's not used by the working group. There are other terms that are often used because we don't have an actual instrument yet. It's hard to say, even name these individuals who we're speaking of. On the first issue, should you have different rules applying to judges versus arbitrators? I'll highlight a couple of arguments made in the working group here. The United States delegation, for example, made the argument that there should be 1 set of rules, mainly for the reasons that Martina, I think, highlighted in a different context. It's important to have uniform application of ethics rules, and to have different rules for arbitrators versus judges could lead to kind of division and a greater differentiation of conduct when ethical conduct should be sort of one size fits all. And I'm describing this in general terms. A US delegate might describe it differently. This is how I view their argument. The European Union argument was different. I sensed flexibility on the modality question. Is it 2 codes or is it just 1 code with different types of provisions? But the European Union did insist, going back years, that there should be different standards for judges. And you can look at the written comments that the Commission submitted in the working group, and you can see some of the reasons. And so they, for example, highlighted the need for different provisions related to double hatting, different provisions related to the obligation of diligence for judges, different disclosure obligations. And here, this is as a side note, the initial drafts from the Commission suggested almost no disclosure obligations. When you look at paragraph 2 of Article 11, this sort of laundry list of disclosure obligations, the EU position was judges should not be bound to make these disclosures, only the sort of uncitral ICSID type of disclosures of, where there may be a circumstance giving rise to justifiable doubts, not all the others in paragraph 2. At the end of the day, the EU effectively won this argument that there should be different rules for judges and arbitrators. In all candidness, I'm not exactly sure why. The chair and the secretariat, I think, seemed to accept that there were some differences that needed to be complicated or accounted for in the text, but it wasn't something I think that was hotly debated at that point. On the second issue, one code or two, again, to me, this is an issue of form, but it's nonetheless significant. And here again, I think there was so once you've decided you're going to have different rules, you have the question of, well, should it be 2 codes or 1? In my view, there were a number of governments, delegations in the September meetings last fall who made a very practical argument that there are some delegations that are going to want to bring the code into being immediately in their treaty practice with respect to ad hoc arbitration, traditional arbitration, ISDS. And for those states, it would be an encumbrance to have one code because the code applying, or the parts of the code that would be applying to the judges could not be finished this summer because the court itself is not yet designed. And so in order to facilitate these states that want to apply the code immediately to ad hoc arbitration, either through their treaty practice or even through soft law, let's divide the code. Let's bring the arbitrator code into being immediately, and let's postpone on the court. And so that argument, I think, was persuasive to many delegations. But then the third issue, and I think I'll try to speak briefly here, but I think this is really the most interesting issue, both for the discussion around the 2 codes and also for what it may portend for future discussions in the working group. Why are we talking about a code for judges at this point? Or should we be? We don't have a court yet. And here, I think an important reminder on the status of the discussion around a permanent court. The Secretariat has done drafting on the sort of the statute that would create the court. One paper, this is WP 213 for those following at home, circulated in the fall of 2021. It was discussed by the working group in meetings in February of 2022 and September of 2022, but there's not been agreement on anything yet, including whether to have the court. And it's not slated for discussion again, meaning the text that would create a court, not slated for discussion until 2024. And so what are we talking about here? We don't have the court yet. Why are we talking about it? And I think here this goes to the politics of the working group, that the European Union is anxious, maybe desperate, to show progress in creating the multilateral investment court. And they also appear to take a sort of zero-sum view that they don't want to allow reform of the ad hoc system in the working group to outpace the development of the court. And so they have, and I say the European Union, but there are other governments that share their view, want to make sure that any reform applying to ad hoc arbitration is matched with reforms, discussion of reforms that address the permanent court. But I think here, and this goes to, I call it politics, but it's sort of the strategy that you see in the room and the gamesmanship. But I think there are some inconsistencies and other issues, maybe even absurdities that flow from the way the working group is handling this. And I'll provide 2 examples. I think one, and this is a point that's been made by the Armenian delegation and some others, we haven't yet decided whether to have a court with permanent judges or to allow part-time judges. And yet, for example, Article 2 of the code applying to judges addresses the obligation a judge may have to declare other functions or occupations. Again, that may not even be available to judges, and yet we have this text. The other one, I think, is maybe even harder to justify or explain, and this goes to the issue of double hatting. As discussed by Chiara at the outset, there is a cooling off period that applies in the code for arbitrators under certain circumstances. For example, an arbitrator can't take on counsel work involving the same provision of the same treaty for 1 year after they conclude their work. The rules in the code applying to judges are totally different. there is a 3-year cooling off period for council work before the standing mechanism. There is no restriction on a judge to, for example, right after ending their term on the court, to take on a case in an ad hoc setting addressing the same treaty, the same provision of the same treaty, same parties, et cetera. And so you have these kinds of discrepancies. I think that the view, and maybe Jay or others could speak to this, the view is that this will all get sort of worked out in the wash, that the commission will adopt the code for judges in principle, and then we'll resolve some of these issues later on. We'll talk about this, but I would ask when and how, given that the schedule that we have, that we're working under, is quite challenging. And these issues may give rise to significant policy differences. These are not simple issues. The other point that I would raise, though, and I don't want to be too provocative here, but in the discussion around the code for judges, there was, in my estimation, not a lot of participation or even interest in the room. The conversation went extremely quickly. I would even go as far to say, if you ask delegates in the room to highlight maybe 2 or 3 differences between the code for judges and the code for arbitrators, that most would be hard pressed to identify even one. And that's not a criticism of the delegates or of the court. We just haven't gotten to the discussion yet around the court, so it seems somewhat premature. And this all speaks to the fact that, if we go and negotiate a court, a lot of these issues that we think are settled in the code for judges may in fact not be settled at all.
Well, thanks very much for that, Lauren. I think you were provocative, and I think you threw out a few bones there for people to chew on. I'll invite the panel, and Jay can go first. I know your name was taken in vain a number of times, as was the commission, and references to politics. Oh my God, and heated discussions and differences, which is only part of the process of arriving at these types of reforms. But Jay, any comments on any of that? I won't require you be responsive to some of the more provocative statements by Lauren, but happy to hear your views.
So I think I think Lauren did mention it, but I think one of the reasons for having 2 codes instead of 1 was the fact that the working group has not decided on whether to establish a standing mechanism. That's still on discussions. The selection and appointment process will likely need to be discussed, and that would actually have an impact on how the code is to be applied. And the operation of the standing mechanism itself is also not determined. So for example, if a challenge were to be made, who would it be made to? And all of those questions are pending. So I think that's why there was the need to actually bifurcate the 2 codes into one for the arbitrators, which can already be in practice, and the code for judges needed to be kind of developed further. And if you look at the code for judges, there's a reference to the rules of the standing mechanism, which is, of course, what is going to determine how the code for judges would be applied in the context of the standing mechanism. So I think that's what led to the 2 codes being prepared. As Lauren has mentioned, and that is why the commission will be adopting the code for arbitrators, whereas it will be adopting the code for judges in principle. It is not that the code for judges would be revised, possibly revised, but the idea is that it will be adopted in principle, subject to the further considerations of the issues that are still pending on the standing mechanism. On Lauren's point about different standards, I would have to disagree, in the sense that I think the working group tried to apply the same standards for arbitrators and judges to the extent possible, and they only deviated the standards when there was the need to kind of deviate the treatment of judges in the context of their role. So whether the 2 codes have totally different standards, I would totally disagree. I would say that the working group tried to apply the same standard to the extent possible.
Well, thanks very much, Jay. That helps a lot. Clearly, as you say, it's a set of rules in principle, and we may yet see more discussion down the road. So if we're using the analogy that this is a meal, this is a bit of an amuse-bouche, an appetizer, and that perhaps when we get to the main course, we'll see more. So thank you very much to both of you. I think the panel has exhausted this for the moment, but we did kind of tip up the next issue, which I wanted to touch on, and Kier also set the table for this issue, and that is double hatting. And I have in my notes, what is the big deal? why has this enamored and fixated and become an endless topic of conversation in conferences and papers, academic papers? Academia has become particularly interested in this topic, looking at Chiara. It really has stimulated a lot of discussion, and we've seen that reflected at Working Group 3 in Article 4 of the Arbitrator Code. And we seem to have come to kind of a middle ground, certainly not elimination of all double hatting, you know, the idea that you could be a counsel and arbitrator at the same time, or an expert and arbitrator at the same time. But there are now kind of actual a box around it. There's some rules and some terms. And I was wondering if, Lauren, you could jump in initially and give us a little bit more detail on those new rules, and perhaps a sense, help to answer my question. What is the big deal?
Thank you, Ian. I think in my former role as a treaty negotiator for the United States, I think I saw the development of this issue as initially a somewhat parochial issue to one that was really at the center of the debate around whether investor state dispute settlement is legitimate and whether it produces outcomes that are fair and balanced for both states and investors. I will try to make a few guesses as to why. I think, so you have some recent treaties that have some restrictions on double hatting, including the CPTPP, USMCA, others. I think prominent figures in the field, mainly on the academic side, but not just, have made very vocal criticisms, including Philippe Sands, for example, and some of those articulations have been very influential. And I think for stakeholders, the public, I think the difference in investor state between what they see in their domestic courts and in international arbitration has been at the minimum kind of striking. For those who are not practicing in this field, the notion that there could be double hatting, I think, comes as a surprise. And there are other reasons too. And in the working group, I think all of that background informed, I think, the delegates' viewpoints. And in the working group, I think this is, in my view, an issue where there is a fundamental disagreement of principle. And I think Chiara highlighted this very well at the outset, that there are some states that want disclosure. Well, there's some states that think it's an issue that does not need to be addressed at all. Others that want some kind of disclosure. Others that want tailored restrictions on double hatting in certain circumstances, and others that want a total prohibition. Then others that want long cooling off periods. You have many areas of disagreement. And states, I think, from the beginning of the discussion, have been in different camps. And I'll highlight, some of these states. I think states that have indicated they want to severely restrict double hatting include Argentina and Venezuela, India, Sierra Leone, Zimbabwe, Ghana, Kenya, Pakistan, Morocco. On the other side, there are states that want to take a more measured approach. I would reference Japan, the UK, the United States, Singapore, Switzerland, and Russia. And I do list these states with hesitation because there is a lot of nuance in their positions, but I think that's a general snapshot. Chiara already addressed some of the arguments that critics of double hatting make and that the other side in the debate also makes. So I won't reiterate them here, but I will talk about the compromise that was reached and the impact of the compromise on the system. And so to me, there were actually two compromises. The deal was struck, as it were, in the March meetings recently, but the first compromise was actually in January in the working group meetings in Vienna. The sticking point in the discussion was two cases that involve substantially the same or similar legal issues. This was floated by the chair as something of a compromise text of let's restrict double hatting where there's same measure, same parties, and also where the two cases involve substantially the same or similar legal issues. This was not accepted by the parties that did not want overly restrictive approaches to double hatting. And so in the first compromise in January, that text fell away, and in replacing it were a few different elements. The first was a willingness to explore cooling off periods. The second was a new disclosure obligation, an obligation to disclose any prospective concurrent appointment. And so you'd have to disclose, if you're an arbitrator, any potential double hatting appointments. Then there was another prong of Article 3 on independence and impartiality to give disputing parties a chance to assess whether taking the role would violate whether there's a question of whether there's a prospective interest or not. And then fourth, some other language in the commentary to flesh out the purpose of all of these different provisions. Now, the second compromise was on cooling off periods, and this was reached in the March meetings. There was agreement on having cooling off periods in certain situations where the two cases involve, again, the same parties, 3 years, where the two cases involve the same related measures, 3 years, and then where the two cases involve the same provision in the same treaty, 1 year. And so this compromise was 3-3-1. And this was during the last afternoon and evening of the discussions in New York in March. You heard delegates around saying 3-2-1, 3-1-1, 3-0-1, and finally we landed with 3-3-1. And it was the several African delegations led by Sierra Leone that really held out here, that held out on having robust restrictions. They would not accept 3-1-1 or 3-0-0, for example. They wanted 3-3-3, which finally became 3-3-1. So two final points. Why did this all take so long? That this discussion around double hatting really delayed, not alone, but with a lot of responsibility, delayed the whole discussion of the code for a year. And so again, I think one reason is disagreements of principle. Another is in the working group, we've learned that there really are not any low-hanging fruit. I think there are low-hanging fruit in comparison to other fruit on the same tree, but all of these different fruit are quite hard to reach. And then I would mention the schedule, which is really stuffed in terms of issues that, notwithstanding the urgency to complete the code, in the meetings preceding March of 2023, you had 2 days of discussion here, 3 days of discussion there, never enough time to address it. Now, the impact of the provisions on double hatting, I think overall you have a very balanced outcome, one that is that many in the room disagree with, but that's probably a sign that it is the middle. It is something like a consensus. I think from an investor perspective and from the perspective of those who want maximum party autonomy, the most problematic outcome of this compromise is the same treaty, a double hatting ban. Again, this is the restriction on taking on concurrent cases involving the same provision in the same treaty, and then also a 1-year cooling off period in those circumstances, particularly in the case where you have a treaty that is frequently litigated. And so often these regional agreements or agreements with lots of parties, thinking about the Energy Charter or CAFTA, for example, in having a same treaty restriction, you are taking a lot of arbitrators out of circulation. You're also taking a lot of potential counsel for both states and investors out of circulation. And I think that's something that some other delegations have raised throughout the process, and that we'll have to see how it plays out in practice. I'll pause there.
Well, thanks very much for that, Lauren. I think that set things up nicely. It is interesting how in the timing we do have these three elements, and as you say, for the instrument of consent, it's 1 year. For same or related parties and involving the same measure, it's 3 years. So there was a differentiation. I know that the idea was maybe 3 years for everything, or trying to equalize it all, but we did have that one consideration. So again, I'll actually put this out to the panel, and maybe Martina could jump into this first. Any further comments on double hatting and particularly from the ICSID perspective, and perhaps even going back to a bit on how that will work.
Yeah, sure. Yeah, the question is not new. Obviously, we've had these scenarios before. And it's also something that is generally covered under the ICSID rules, under independence and impartiality. So that's the lens that you look at it from an ICSID perspective. And I would say that the two first prohibitions under Article 4.1 that you cannot act concurrently as an arbitrator and as counsel, dealing with the same or involving the same or related parties or dealing with the same measures. That is a no under any rules. That is flat route conflict of interest. And I don't see any scenario where when a person acts concurrently in both roles, and that does not amount to a conflict of interest. So I think that is fairly clear, and there should be no doubt about those situations. Now, the prohibition to act concurrently as an arbitrator and counsel in ISDS cases under the same provisions of the same treaty, now that's different. But I would say that the situation is not very common, or at least it hasn't led to challenges before ICSID. And we actually made a background paper on this that we published on ICSID website. And there are no ICSID cases that deal with that kind of situation or that kind of challenge. And we haven't really seen many instances where a former arbitrator would have subsequently represented the same or related parties or dealt as counsel with the same measures. So that means like the same state, same measures, and you would have acted first as arbitrator and then as counsel. That's extremely rare. So I think that the 3-year cooling off period there might actually not have that much of an implication in practice. Now, the 1-year cooling off period for a former arbitrator not to act on the same treaty, that's a different matter. And as I said, I do think that counsel who act as arbitrators will think twice before accepting a role as arbitrator.
I don't want to get off this issue because obviously I'm obsessed with double hatting, but Marin or Chiara, maybe go to Marin next. I mean, clearly there has been a part of the heated discussion and goes to, the impact. And it sounds like the potential impact, at least based on experience, may not be as great as some have said. But do you see any issues or project any potential problems? Marin.
Well, I think the code itself, as Lauren explained, is a compromise. And in the end, I think if I could, summarize, encapsulate it, I would say that the code in its current form opted for clarity over breadth, right? So the provisions that it adopted on double hatting are pretty, well, I shouldn't get too ambitious on saying that they're going to be easy to implement, but they are at least clear, right? Same instrument, same tree, same provision. We can pretty much identify those. And that's not as broad as some of the proposals that were out there where they were talking about the same or similar legal issues or even same or similar instruments. I mean, same or similar instruments could potentially, depending on how you define it, capture all 2,800 bits. So clearly the code opted for clarity over the kind of breadth that has been proposed. I don't think, though, that this ends the discussion. I think that proponents of bans on double hatting or more expansive understandings of what double hatting is are going to continue to press for that. And I think there's still going to be continued pressure on arbitrators who were once counsel to declare themselves pure, right? To say that they're only one or the other and that this double hatting thing will never happen for them. And that I want us not to forget that that's going to have serious consequences for professional development, for the diversity of the pool, and particularly for generational diversity. Everybody who's out there arguing that we should put a ban on double hatting, I don't want them to tell me 5 years from now that they can't appoint somebody because they don't have any experience. So that excuse had better go away if you're also telling me that there can't be double hatting in any form or broadly understood. After 25 years of practice in investor state arbitration, I can think about going and being an arbitrator only. My colleagues who have done this for 10 years can't make that decision, can't make that call, at least not without great personal risk and professional risk. So I do, because I think the code is not the end of the discussion. I think we still have to be conscious of what are the consequences for the discussion that's going to continue.
Kiara?
Thank you very much. Very, very briefly, three very quick, very briefly, three quick points. One is I agree with Marin that the provision is clear, and this is a welcome fact. But we do need some way to kind of find the data. This is the disclosure of where the appointments are. How are we going to collect that? I think it relies a lot on arbitrators and themselves, but I think we need to establish maybe a mechanism to know who's serving where, and maybe public mechanisms. ICSID, of course, has a lot of the data available already, but maybe some other institutions are not. And so how do we know who's arbitrator, who's counsel? The other is, why is it such an important issue? I think there were three issues that were specifically tasked by Working Group 3 to the ICSID and Antitrust Secretariat to look at. One was issue conflict, multiple appointments, and double hatting. And of the three, now what we really have is double hatting. This has been a hugely important issue from the very beginning of the code, and so I think it's very important that we have developed here. The third, 3 seconds, the impact on diversity. I'm not sure that the impact on diversity is how it's going to be. So it's how it's going to it is how it is portrayed now. I think there's much of a likelihood that if we prohibit double hatting, we have, as I said before, more spots available for arbitrators. And so there's no risk in taking somebody who's not, who is set as an arbitrator. We should not consider this as a risk because it's prohibited. So we'll have more spots, and then we will have to appoint those who demonstrate maybe their knowledge or their ability in possible other ways. But I think it's a chance to have kind of more spots free that can be filled by diverse candidates. I wish I were that optimistic. I just think the same spots are going to get filled by the people who've declared themselves, to have made the transition. And then we're going to wind up with a generational gap in between.
Well, I guess this is going to be, the diversity issue is certainly one that I've always been concerned about, and I think many on this panel and other folks in Working Group 3 have been, of course. A lot of this goes, I think, back to even like Jan Paulsen wrote his moral hazard article in 2010 or thereabouts, basically decrying the idea of party-appointed arbitrators. And I think we're over that issue largely. I think the value of that particular ability of the parties to appoint arbitrators is pretty well established, and we're now moving to the code as a means to try to mitigate some of those issues. But something to watch. I don't think we'll stop discussing this issue. But with our last few minutes, since we started a little late, we're going to go a little late as well. I wanted to actually start off with Jay to what I wanted to title the kind of the next steps, the future of the Working Group 3 process. When we started back in 2017, and I have to confess, I was an observer at the 2018 spring meeting, and this was an ambitious agenda and impressive, and there were all sorts of elements to it. And the fact that we're now here, 5 years later, with some really tangible, productive result is fantastic. But the agenda is a big one, and I wanted to get your sense. Maybe just comment briefly about, because I don't want to ignore it, but I don't think we have time to get into it deeply, the mediation materials, guidelines, and so forth that we're going to see adopted, as well as the next steps to be discussed in the fall.
So just one point on the double hatting. I think Kiara did mention it, but the fact that the parties can agree otherwise, possibly imposing more bans or actually lifting the ban, is something that we would like to see how it's going to turn out in practice. It's something that we're very interested to look into. Now, on the plans, As you mentioned, the two texts on mediation, which is the text on mediations to be included in investment agreements, and the guidelines on investment mediations are going to be adopted by the Commission this year as well. That's going to be on the first topics of the agenda. So that's going to be on Monday and Tuesday. And then the code will be discussed on Wednesday to Friday, including the commentary. It is expected that the code and the commentary would be adopted at the same time at the Commission in July. Just so that you know, the working group agreed on a work plan to present some of the reform elements in staggered form. And what is expected to be discussed for the Commission next year, so it's in 2024, is the Advisory Center. And that is why the September session has the Advisory Center on its agenda. What is to be presented to the Commission in 2025 is the procedural rules reform. And therefore, we're hoping to have a first initial discussions on the procedural rules in September so that we can have an idea of what the Secretariat is supposed to expect it to prepare for that 2-year process. On the question of the standing court, it is not on the agenda for the fall session. However, we're going to have an intersessional meeting in Singapore in September to look into the different elements of the standing mechanism and the appellate mechanism. So that also gives into and feeds the Secretariat with some information about the different views on how to present the text to the Commission in the year times to come. That is to become in 2026 in 3 years' time. So we have a work plan in progress, and the documents are being prepared in that order so that the Commission would be able to adopt the reform amendments as time passes.
Thanks very much, Jay. Sounds like a full agenda. Since we have a few minutes, I'd actually ask Martina to touch on the mediation topic, partly because this is one of my favorite topics to discuss at conferences. And we have actually addressed this in some earlier panels in Mexico City in particular. There was some discussion about the new ICSID mediation and fact-finding rules. But obviously, the new mediation documents that have been prepared in UNCITRAL are really further advancing the use of mediation. If you could just give us a couple of minutes, Martina. I know this is an issue that you've spent a lot of time looking at too.
Thank you. Yeah, as Jay mentioned, the working group concluded its work on draft provisions on mediation and draft guidelines, and these will be presented to the Commission for approval. And as you know, ICSID adopted its own mediation rules for investment arbitration or mediation last year. And it has been supporting the work of UNCITRAL and the working group throughout this process. Now, the working group 3 draft provisions on mediation are intended to be used in investment treaties or multilateral instrument on ISDS reform. So they provide for the entry into mediation, the relationship with arbitration, and other dispute settlement proceedings, use of information in other proceedings, and the settlement agreement. But they don't regulate the conduct of the mediation. And the idea is that other rules, like the ICSID mediation rules, will be selected by the parties for conduct of the mediation. So basically, it would work like dispute settlement works in treaties. You would get an option and you select. So the intention is to include these provisions in investment treaties or the MIRA. Now, the mediation guidelines in turn explain how mediation can be used effectively in ISDS, similar to the background paper that ICSID published, and that's on our website. Among other things, they encourage the use of specialized rules for ISDS mediation and to consider institutional support. And when the ICSID mediation rules are selected, you automatically select ICSID as the administering institutions, but ICSID could also administer under the IBA rules or the UNCITRAL mediations rules. And then there's the dispute prevention draft legislative guide that wasn't adopted. States felt that it might not be the most appropriate format to address the issues because there is no one size fits all approach to dispute prevention. So that's not going forward. But mediation is going forward, and we're very excited about that.
Well, let's hope this continues the momentum in favor of mediation, and we'll actually start seeing some mediations soon. So we only have a couple of minutes left. If each of the panelists can just give whatever final thoughts they have on the future of the Working Group 3 process, or on the code, or any of the issues we've discussed today, I'd invite you. Now is the time, and then we'll close up. So I'll start with Lauren at the end, and of course, talk close to the microphone.
I'm going to swallow the microphone. Apologies for not being clear earlier. In 30 seconds, I would say that a few things for the future. The code is not done yet. That's something important to acknowledge. This summer at the commission meeting in July, issues in the commentary will be addressed, including on implementation, I think, that are quite important. And so before declaring victory or failure, let's see what happens in July. It is important, in my view, that it does get done for reasons that have been articulated. I think it is a very significant achievement, for states to get together and to approve a set of ethical rules that will guide ISDS, whether a soft law, hard law, or something in between, for years to come. And it's also important for the working group's progress itself, that this is a demonstration that the working group can deliver outcomes, which was not certain when this process started. And it, I think, will give some momentum to other reform discussions. Final word. Now, with that said, we're out of the pan and into the fire, as it were, that these issues are not getting any easier. I mentioned an overstuffed agenda, my term. There are 8 baskets of issues in the work plan that need to be wrapped up by 2025/2026. We're already a year behind because of the work it took to complete the code of conduct. I think there's a real challenge here in prioritization and efficient and effective use of time in figuring out how can we do all of this, and are there things that we need to prioritize? Are there things that we need to hold for future work? That's a question that I think, whether we look at it now or later, we're going to have to look at it at some point.
Thanks, Lauren. Jay, could you give us a few thoughts?
So on the dispute prevention, I forgot to mention that it's not off the table. It's still on the table. It's just that I think the working group did not like the format of how it was presented, and therefore we're working on the dispute prevention paper to present it possibly to the commission next year and to the working group in between. I think, as Lauren has mentioned, there's a lot on the table, but I think there has been a moment of compromise, and I think that momentum needs to be kept up so that the working group keeps on agreeing to a number of different policy questions that they have to address. And I think because of the fact that they were able to agree on some of the more tricky parts of the code, I think it was likely that the working group is able to agree on other policy questions that are coming their way with regard to more politically sensitive issues. The Secretariat stands ready to support the working group, but we rely heavily on experts and their comments and their interventions and their comments on the drafts that are prepared by the Secretariat to prepare the document. So we would hope to see more, comments from experts coming our way so that we can prepare for the working group itself.
Thanks very much, Jay. Marin.
I was thinking about how to play off of Lauren's point earlier about low-hanging fruit and how there isn't any anymore. I mean, I feel like if there was any, relatively speaking, the code of conduct had its challenges. Mediation is sort of one of those things that nobody doesn't like it. So that seems like something that can move forward. The advisory center sounds like a lovely idea to keep everybody, to put everybody on the same level playing field. Procedural rules sound innocuous, although again, I'll ask Martina if renovating your procedural rules is actually innocuous. And that whole bundle of activity is itself very challenging. I can't even imagine what we do with the rest. So there's a lot of work ahead, that's for sure.
Well, that's a good pass off, Martina. Thank you, Marin.
Yep. Procedure rules, yes. We know a lot about those. And of course, some of those that we have already adopted are being discussed now in Working Group 3. And so I just wanted to say a few words about that. We do not need revised ICSID rules at this time. My priority is really to apply them and see how they work in practice and to reassess if need be. So, we don't think anything needs to be changed. In fact, this should be low-hanging fruit for Working Group 3 to, work further with the ICSID provisions and, maybe do a few tweaks if you don't like them, but in essence, to steer that way. But the Working Group 3 may wish to consider how to better align the UNCITRAL rules for use in investor states arbitration, because they are not covered by anything right now. In fact, Working Group 2 is steering in a different directions. They do not plan to adopt the same type of provisions. So these are the main rules that need to be updated, and the working group should consider how to do that in the most effective manner. And I am not persuaded that a multilateral instrument is the way to go.
And Kiara, we started with you. The last few words are yours.
Thank you very much. I'd like to just make a comment on process rather than substance, and what are the consequences of having a successfully concluded the code. I have seen, at least it is what my observation was, that states and delegations in general were much more involved in the final parts of the codification of the realization of the code. And so I wonder whether what we will see now is much more involved delegations, so that maybe this is optimism, I don't know, but is it now that states have realized that this is for real and these reforms can be done, and anyways are consequential, and so will they be more involved in the discussions to come? With more concrete and more negotiations, like value negotiations, more like really looking at the details of what is being discussed rather than just general issues.
Well, thank you so much, Kiara. I mean, one issue that clearly has come up here, and I have discussions like this with students, is sort of the advantages and disadvantages between kind of a soft law approach, a more practice oriented, following codes, the basically the idea that the profession and the practices evolve and they become practices, and that as a group and as a community, these start to become recognized. And then, of course, there's proponents of hard law, of instruments, of enforceable things. And I think the part of the lesson is, and maybe, good for the students in the room, is that there's room for both. And certainly in the international arbitration world, soft law is being used to great advantage and a high level of usefulness. So, but we will see more. We will likely see a lot of developments over the next few years in Working Group 3. And I think for the time being, as Martina was saying, we're going to watch how the new rules, the reforms at ICSID unfold, and we will likely be having a panel like this next year, I suspect, seeing where we are at that point. But I'd like to thank our panelists. This was a true all-star group, and it was a lot of fun talking about these types of issues. And I am going to say very little now, other than it's been a pleasure this week. We've had 23 panels and 2 speakers over the course of the last 6 days. World Arbitration Update has once again, I think, been a success, and we thank all of our attendees and all of our speakers and moderators. I'm going to pass it off to my co-chair, Dr. Jose Antonio Rivas, who's, despite the picture behind him, which he looks like he's in his home office, I believe he's in Bogota, to close off the conference and say any final words. So, Dr. Rivas.
Well, thank you, Ian, and I am in our Bogota presence office, as you can see. actually, we are at the Academy of at the Colombian Academy of Jurists, where the event on humanitarian law and investor state arbitration took place. I would like to thank each one of the speakers now in Washington, D.C., at Carl, Marin, and Lauren, and Martina, and of course Jason, who is, I believe, in Vienna. So thank you so much for being here. I'm sorry that I am not in Washington, D.C., but I was trying to make it here to Bogota, which I finally did. Apart from thanking this panel, because it really did a deep analysis on the issues of the code of conduct and even on the differences between the code and the code for arbitrators and the code for judges. I believe that we've also had a wonderful week or 6 days of proceedings at World Arbitration Update. During this 6 days, we've been in Mexico for 2 days with eight panels. Washington, D.C. has had one panel. Madrid has also had one. Bogota has had one. Overall, we've had between 12 and 13 panels in person. And we've had, now we're looking at the number 1,690 people registered and attending the conference. So it can only be expanded. And as some of you know, one of the beauty of World Arbitration Update is that the sessions are recorded, because some people now are sleeping in Asia. And when the Asian panel takes place, we might be sleeping. So the idea is really to put this out there so that researchers, lawyers, students are able to get a hold of it, and that will come with an added element that we're perfecting, which is an automatic transcription tool that is already out there in the World Arbitration Update. So with this, I would like to really thank all the panelists, all the moderators, because there's a huge amount of work to do a panel well, and I think that they have been all been of stellar quality. In addition to that, I would like to thank Maria Lucia Casas, who has been a force behind this, and Juan Pablo Rodriguez, who has also been a force behind this, and many other people that are there. Moderators are always, so committed. They meet with people. They put the issues there. Marin and Ian and Meg and our partners from the Mexico arbitration days, Ricardo and Hugo, etc. Everyone really deserves a huge amount of credit for this enterprise. So hopefully next year in 2024, we will have news perhaps about the advisory center. I'm not entirely sure that hopefully, I would say hopefully about any investment court, but that's a personal comment. And having said that, thank you. And the next real event is the Washington Arbitration Week, which happens right after Thanksgiving in US holidays, which will be between the 27th of November and the 1st of December. So we already have quite a bit of people wanting to speak there, sponsors lining up, and people wanting to host the event. So thank you and have a beautiful day.